Good afternoon and welcome back to C-IP2's annual fall conference on artificial intelligence and intellectual property. You are joining panel 2, which is on the economics of artificial intelligence and intellectual property. My name is Donald Koshin. I am the Deputy Executive Director of the Law and Economics Center here at George Mason University's Scalia Law School, where I am also on the faculty as a professor of law. It's a pleasure to be with all of you today. We have a wonderful panel lined up to discuss artificial intelligence, intellectual property, and the economics of each. And rather than give long bios and eat into some of our time, I'd rather just dispense with the long bios and let everyone refer to the materials associated with this program for understanding the deep expertise that each of our panelists brings to this conversation. We have 4 panelists who will be discussing these issues today. The first is Mark Baker. Mark is the Senior Vice President for Public Policy and Governmental Affairs at Warner Music Group. We then turn it over to Nicole Spence, who's a senior IP attorney at IBM, followed by Ian Slaughton, who is the Senior Vice President of Intellectual Property at NBC Universal. And then we have Brian Mills, who is the Director of and Assistant General Counsel of Capital One Ventures and Technology. The issue of the economics of intellectual property and artificial intelligence surrounds the basic issues that we understand about intellectual property in all fields, and that is, how do we spur innovation? How do we incentivize innovative and creative activities? How do we encourage investment in these activities? How do we foster competition between both all parts of artificial intelligence, as well as spurring competition between artificial intelligence and other formats? And how do we protect interests both of persons and their rights, but also interests of other competitive fields as artificial intelligence emerges and continues to grow and perhaps creates new opportunities to compete with those fields? So I think we're in for an interesting continuation of the discussion here at this conference with this panel. And so we will have each of our panelists present about 8 minutes of opening remarks, after which we'll have some intra-panel discussion. And then we'll open it up to audience Q&A. Please do submit your questions at any time, and we'll review those questions for purposes of asking them of our panelists at the end of the opening remarks. So with that, I'm going to turn it over to Mark Baker to get us started. Mark.
Thank you, Don. So just a point of introduction, thank you for that introduction earlier. Warner Music Group is one of the world's leading music companies. So our business spans both recorded music and music publishing. Some of our record labels that you may be familiar with include Atlantic, Elektra, Warner Records, of course, Parlophone, None Such. Some of the artists who are signed to us include Aretha Franklin, Ed Sheeran, Bruno Mars, Cardi B, Lizzo, and lots of others you probably have heard of. Warner Chappell Music is our music publishing business, through which we own rights in about 1 million songs and have about 70,000 songwriters and composers signed to us. AI is ubiquitous nowadays, is affecting all aspects of our lives, including the music industry. So today, AI is used as a creative tool by our artists and songwriters, and currently used, for example, in production music and some meditation music. And we think forward about some exciting opportunities that AI might present. And we could envision, for example, AI being used to generate workout music in the moment based on biofeedback that it's receiving as you do your exercise. But AI also generates a lot of questions for rights holders. And so these issues and questions are really complex. And so in my remarks today, I'm going to talk a little bit about where the recorded music industry is aligned. And I'm going to talk a little bit about some open questions where we have not yet landed on a position and some of the complexity that some of those questions present for us. So first, let me start a little bit with where there is alignment in the industry. First, our industry is aligned with the notion that using protected content to train AI is a licensable act. So training AI necessarily means creating a copy of our content on the AI system, which under US law requires a license. Whether and how recorded music is used by third parties is an exclusive right that is reserved to sound recording owners. And furthermore, the music licensing market is functioning and vibrant, and it allows us to negotiate terms of use with the users. And many of the concerns related to how our content is used and some of the questions regarding the output can be addressed and agreed in those licensing discussions. Second is that there's no justification for a general exception to copyright for use by AI algorithms. In fact, we would argue that a machine should not be treated differently and certainly should not be treated more favorably than a human by being granted free access to protected content. An exception to copyright for use by AI algorithms would essentially put the creative industries in the position of subsidizing the AI industry. Third, is that existing law regarding infringement is sufficient to deal with the instances of infringement by an AI algorithm. Infringement is infringement. It shouldn't matter if the infringement is by a human or by a machine. But I think who bears the liability for infringement is a very interesting question, and can vary depending on the case, and really should be determined on a case-by-case basis. Finally, AI users should be required to keep records of the protected works that they're using to train their AI. And in the absence of record keeping, should create a rebuttable presumption of infringement. So let me turn now to some of the more interesting questions, which are really around, which again, we haven't really landed on an aligned position, but the big question is whether AI generated content should be eligible for copyright at all. On the one hand, we could argue that it should be copyrightable. So from a commercial perspective, our business rests on our ability to monetize and license our content, which is predicated on it being copyrightable. So to the extent that this is the future, this is the direction of travel, we certainly would want it to be copyrightable. If we also think about in the absence of being copyright, it raises the question of whether AI-generated music, if produced in volume, undervalues or undermines the value of human-created music. From a practical perspective, if we agree that AI can be used as a tool to generate music, and that's copyrightable, as it is currently today, but autonomously generated AI music is not eligible for copyright, but it raises the practical question of how do you measure that, and how much content or AI-generated content makes it no longer eligible for copyright, and how do you enforce that? Allowing AI-generated content to be copyrightable avoids these virtually impossible challenges to enforcement. We could also then, on the other side, argue that it should not be copyrightable, right? The fundamental essence of copyright is to protect the output of human creativity, and by extension, to allow creators to monetize and have a living from their work. US copyright law currently requires some level of human creativity and input as a precondition for copyright. If human creativity is required for copyright, then AI-generated music should not be copyrightable. But then that leads to the question of how much human content is necessary, contribution is necessary. So is it enough that a human wrote the algorithm? Is it enough that a human chose the universe of works to train the AI? And is it enough that a user chose the parameters for the output, the rhythm, the instrumentation, the tempo? All of these are human choices, and could argue that we could grant or make the works eligible for copyright. Another interesting question is, if AI-generated output is copyrightable, who owns the copyright? I mentioned earlier, the licensing market. I think here's where licensing can be useful. So, for example, if we license the catalog of Ed Sheeran to create a new music in the style of Ed Sheeran, you could argue that we should be able to have some stake in that output. Similarly, today with certain AI tools, the user can decide if they want to have the free option or the premium option. If the user creates new music using the free option, the AI company owns the output. If they choose to use the premium paid service, then they own the output. So here's an area which we haven't really landed on clear answers to, but licensing and contract law can actually provide a mutually agreeable way forward. The last point that I want to make is around this interesting question that was alluded to earlier around how do we protect the likeness of artists in case of deep fakes? And I think we're going to talk a lot about that today. An artist's distinctive voice and style is what makes them successful. So for example, if someone creates a new song using AI in the voice of Aretha Franklin, they choose Aretha Franklin because they believe that her voice has some unique characteristic or value to it that has to be true. Otherwise, they would use another voice or create a new synthetic voice. If it has value, it ought to be monetizable, or at least the artist should have the right to say whether and how their voice is used. Some artists may see AI generating music in their voice as an extension of their creativity. Other artists may see it as a threat to their livelihood. Some states, like New York, have laws regarding the rights of publicity, but there's a gap in the current law. Now, I'm not a lawyer. I'm in a room full of a lot of lawyers, so I get to come up with all kinds of crazy ideas. But I think in this instance, if we look to TRIPS Article 23, is kind of interesting. That article prohibits the sale of certain wines and spirits as protected geographical indications unless they were produced in the protected region and in compliance with the applicable standards and regulations to that product, even when the product is correctly labeled as an imitation, like, type, or kind. Now, I'm not suggesting that artists' voices are GIs, but we could certainly, use this concept to create a similar law where we could prohibit the use of an artist's likeness, even when the output is correctly labeled or presented as an imitation. So let me conclude, because I want to be mindful of time. Look, I presented a lot more questions than answers here, but these are very, very complex issues, and how we answer these questions will have a profound impact on the creative sector and copyright holders. So we need to chart our way forward carefully and thoughtfully. Thank you.
Thank you, Mark. We'll turn to Nicole Spence next. Nicole.
Hello, everyone. My name is Nicole Spence. I'm a senior IP attorney at IBM. I support the Watson AI and Data and AI group in particular. So as you can imagine, I see a lot of AI issues, and I deal with a lot of AI issues on a daily basis. So one thing, and the title suggests data and AI, and one of the groups I support, AI and data are very closely related. I recently, WIPO had a conversation, a recent conversation, the 22nd, 23rd of September, where they talked about data primarily. And in the past, AI has been a driving force in a lot of these conversations, but this time they switched or pivoted to data. And the quote that was said by one of the speakers, if digitalization is the engine of the future, then data is the fuel. And I don't think that couldn't sum up any better if I tried to explain the importance of data. Think of it this way. If in essence you're trying to train an AI model, you need data. And the old mantra of garbage in, garbage out is exactly what you're dealing with. So not only do you want data, you want good quality data, and you also want to make sure that you're not running afoul of any copyright issues, any privacy issues. And that's a lot of what your work is when you're doing data, because data, unfortunately, at this point, there really just isn't the right IP structure as of now to deal with data. But what we find ourselves doing in this wild, wild west world of data acquisition is, in essence, trying to figure out license terms and the best method of collecting that data. And if we're doing third-party data, making sure we're dotting all of our I's and crossing all of our T's. And also doing it in a very cost-effective fashion if you are a data consumer. If you're a data provider, obviously your roles are a little different because you're in essence generating the data in-house. So you don't necessarily have to worry about the cost of getting data from a third party if you're strictly a data provider. Obviously, a lot of companies are a hodgepodge of both, but if you're strictly a data provider, then in essence, you can create or generate your own data and not have to worry about reaching out for a third party in order to get data. But a lot of this focus is on data consumers I want to talk about today, because data consumers are the ones that are in essence trying to get data or obtain data or retrieve data from third-party sources. Some of the methods that can be used are web scraping, which I know many of you probably, there's been some recent cases on web scraping. And mainly what web scraping is in essence, you in essence having two forms. You have a specific web scrape or web crawling where you're in essence looking at very targeted websites and getting data from those targeted websites. Or we have a more broad-based web scraping, which requires you, in essence, to have a seed URL, and that seed URL is, in essence, used to find similar type of data or similar type of sites online in order to get that data back. With the broad-based one, you can get thousands of hit easily on data, different data hits. But with the more specific targeted based web scraping, you're in essence getting very specific data that you're getting from specific sites. You're getting a smaller subset of hits. Obviously, there are things like robots.txt you have to obey by, and making sure that you have to make sure you look at the terms of use for the sites, because obviously there are quite a few sites that have popped up now where you're doing third-party data that in essence do have an issue with you in essence scraping data that is done via machine automated versus manual scraping probably can pass some muster. So the reality is that you kind of have to look into those terms of use. And when you're doing a broad-based web scraping, looking at the terms of use for thousands and thousands of websites and thousands of pieces of content is not only time consuming, it's also not very economical as well, because that requires literally a whole team to do that kind of a work. And legally, there is a lot of back and forth, and the case law is very unsettled for both types of web scraping, whether it's something that you can do legally. There was recently a case Van Buren that did start talking about web scraping, and there's another case coming out, LinkedIn v. HiQ, which is another case that also going to go a little bit more into web scraping as well. So I would definitely stay tuned on those developments, because I think that may open the door to some potential cases and some rulings on web scraping and what we can and can't do. Another area I talked about is all third party, obviously, is licenses. We talked about it just briefly in the web scraping portion I just mentioned. As far as licenses are concerned, that's mainly you in essence having more of us going to a specific third party, whether it be via web, whether it be someone who's actually a data provider, and in essence having a license structure with that particular individual party to get data. The issue you have with that is if it's in essence they're the ones creating the data, it's a much simpler task, but it's much harder when they're in essence kind of packaging other third-party data to provide to you. So in essence, they're not the initial data generator. They're in essence kind of like a secondary data generator, for lack of better terms. The problem with that is you have to make sure that they have the appropriate licenses to pass that data on to you, because it may be a situation where they may have scraped the data as well, and they don't have the right licenses or rights also. And then we're really in a bad place, because now you're getting data from a third party who didn't have the rights to give it to you to begin with. So that becomes a huge issue. So with third party data in a whole, you have to be very mindful of the role that that third party source has and exactly what license they have in place to provide that data to you. The last area on the data and the data umbrella I wanted to discuss was synthetic data. That's a very hot area in which we talked about deep fakes earlier on. But that's a really big area, because now people are trying to get over a lot of the hurdles that you're dealing with as far as the license issues with data and the privacy issues, and potentially creating their own source of data. And that, I think that is a huge issue. And I want to make sure that we're covered. You are very well aware that's a very deep area and has a lot of traction in the area. So definitely keep your eyes and ears open for that. The last area I want to talk about briefly, which could be a topic all of its own, is data privacy. Data privacy is huge, because in that particular arena, data privacy, you have fines with GDPR of 2 to 6% of your gross income. And that's a huge deal, because in essence, that can be a deal breaker for some companies. So I can't say it enough. When you're training AI models, make sure you are taking out the PI issues, in particular, the PI issues as it relates to EU, the UK, and a lot of other countries also have their own privacy law. So be mindful of that as well, because once that data is put into an AI model, it's extremely hard to unravel. So I will now pass it back to our moderator here. Thank you very much for your time, everyone.
Great. Thank you very much, Nicole. We will hear from Ian Slaughton next.
Hi, everyone, and thanks so much to the Institute for inviting me. Really appreciate the opportunity to discuss these issues. I'm an IP lawyer at NBC Universal, and I work with our technical teams on cutting-edge emerging technology projects. I also work on the legal and policy aspects of disruptive technologies and how they impact our business. As folks know, NBC Universal is a global creator and distributor of TV, film, news, sports, and other video content.
And of course, we also create and exploit, ancillary items like merchandise, video games, and theme park rides based on our content. I thought I'd spend a few minutes speaking about some AI use cases in the movie and TV business, and highlight how AI is affecting the economics of content creation and distribution and affecting how people work. In the main, AI is enabling us to meet growing demands for content across different devices and platforms and make our content better. These technologies benefit creatives by freeing them from mundane and tedious tasks and solving logistical and production problems that would otherwise require greater investment and time. But as I'll get to, AI raises some interesting issues for performers, in particular when it comes to digital avatars. So the first use case I wanted to talk about is new products derived from existing animated materials. So the typical process for creating a finished piece of animated content involves a multi-step workflow that takes time, expertise, and effort every time. Once we have a final version of an animated TV episode or a film that's completed, and we want to reuse an asset from that project, an asset being like the 3D version of a character or a setting or a prop, to create other content for a different purpose, like for example, customized augmented or virtual reality content, gaming or social media or other things, you'd have to use that same multi-step process under conventional methods, which could take weeks or more. But with the AI tools available today, we can reuse that character without repeating all of those individual steps. And that reduces the effort from weeks to days and reduces the expenses dramatically. And this opens up a variety of new possibilities for types of content that now make economic sense to create. An example of this is something we launched on Cameo.com featuring animated characters last week. For those of you who haven't seen Cameo.com, it's a service which, for a fee, a celebrity will record a personalized video greeting for you. And the whole point of it, the reason these videos are cool is because they're personalized and they may mention your name and they mention whatever it is that the sender of the greeting wants them to know about you. So we did the same thing for DreamWorks Animation's Boss Baby character. So you can sign up on the website and get a custom video greeting just as you would from a celebrity. In order to do that, we use an AI system to generate the custom video and audio in response to each order. This would just not be possible using conventional methods because the conventional animation process is too lengthy and expensive to justify a custom piece of content like this at a price point that makes sense. So this seems like an example where AI is augmenting the volume and types of content-related products available. At least right now, it isn't really replacing work that would otherwise be done by a human because it's powering a product that would make no sense to produce at that price point in the first place. It is kind of a trivial example as compared to the big ideas for AI and creative works that have been thrown around so far in this seminar, but it is a good example of the capacity of AI to generate entirely new categories of products that now make commercial sense to offer. In the future, it's possible that versions of these technologies could enable reuses of characters or assets to generate longer form professional level content. But even then, to me, I'm convinced that content of any real quality is going to require humans in the loop to make the usual creative decisions. How a shot is framed, how it should be lit, how the camera follows the action, what the characters are wearing, dozens of other creative decisions. The second use case category I wanted to discuss is content analysis, essentially understanding what's in footage or content. So the ability to recognize and tag items or people appearing in videos is really valuable because it allows us to understand what's in those videos. It allows us to even understand videos at a higher level, the mood of the scene, whether there's a conflict occurring, those sorts of things. And then that allows us to match content better with other content and in turn generate better video recommendations for people. In the news and sports area, it is a very valuable because we have a lot of legacy, footage that is not necessarily tagged or labeled. And what an AI tool like this can be used for is to actually determine what's in it and then create new opportunities to reuse that content. One interesting use case in the content analysis category is the ability to use AI to analyze scripts for potential unconscious bias. In February of last year, NBC Universal announced a pilot project with the Gina Davis Institute on Gender and Media at Mount St. Mary's University and the University of Southern California to work with those universities' spell check for bias tool. That tool analyzes scripts to match up representations of characters by gender, race, sexuality, disability, age, and body type with depictions of violence, the amount and types of dialogue assigned to that character, and the character's depicted intelligence. The system's outputs can be used to identify opportunities to increase representation of underrepresented groups and surface instances of unintended bias in character portrayals at the script stage. The initial phase of the project, which focused on developing appropriate criteria for the system to analyze Latinx representation, actually worked out well. And last week, we announced that we're expanding the partnership to include Black and Asian American and Pacific Islander representation as well, and to apply it to film and TV script development. The third category of use cases I want to talk about is using AI to create synthetic likenesses of real people, otherwise known as deepfakes. There's been a lot of attention on this technology recently, and with good reason. As the first speaker mentioned, there's a series of TikTok videos featuring Tom Cruise, which are actually really impressive. And there's the unfortunate use of AI face replacement for sexually explicit materials, which several states have sought to address. But I want to highlight a few of the ways that synthetic video opens up interesting possibilities in mainstream film and TV content. And I think we can split this into two categories. The category of situations where it's done with the authorization and participation of the subject, and when it is not. Starting with when it's done with the participation, this is really about creating an avatar of a performer performing a role that otherwise maybe they would act themselves. So this might be a situation like the example of the young Luke Skywalker showing up in the Mandalorian series, where AI was used to create, a likeness of Mark Hamill that is not possible in 2021 because it's from the 80s. Similarly, when Paul Walker passed away in the filming of Furious 7, one of the Universal films, after he died, VFX and AI technologies were used to have him appear in that film. There's also applications for stunts, for reshoots, where an actor may no longer be available, but yet may be able to go to another project while the reshoots are being done using AI technologies. And there's also a foreign language dubbing application, which is kind of interesting. Foreign dubbing is an interesting case because it leverages AI technology to make one person's voice sound like another. So the idea is to make the characters' voices in the German language dub of a US production sound just like the actors who performed in the original film. You still need to hire a German dubbing performer to speak the lines, at least right now, but the final product is improved because you're now giving the German audience something closer to the experience of those who watch the English language version. So this is an example where the job impacts for performers seem to be neutral, but the final product is improved. The second category is the applications in mainstream media, which are done without authorization. And this could be a situation where performers or public figures are appearing as themselves in a film or TV show, either because they were real-life participants in the events being dramatically depicted, or the work is using them to situate the story in an era or context. Examples would be biopics, like the Bohemian Rhapsody featuring, with the Freddie Mercury biopic, or The Darkest Hour about Winston Churchill. An example of using famous folks for context would be Forrest Gump or Once Upon a Time in Hollywood. In all these cases, actors with makeup and costumes and prosthetics are made to look almost as closely as possible to the actual individuals. And it's clear from that the First Amendment would not permit a requirement that authorization be obtained from the depicted individuals or their heirs, because to do so would inappropriately give them the right to censor public discourse. Digital avatars creating AI could eventually be used for depictions like these. But the distinction between using actors in costume and makeup and using AI doesn't appear to matter from a First Amendment perspective. We don't allow public figures to prevent non-defamatory depictions in expressive works about them. So it's not clear why the technology used to make whatever point the filmmaker wants to make should make a difference. Some have expressed concerns that with the technology being so good, we're just going to stop hiring actors and we'll use digital avatars instead to perform roles. I think this concern's overblown. We've had celebrity impersonators for a long time, and it hasn't detracted from the demand to see the creative choices the real person would make on film. The fake Tom Cruise video on TikTok are really good, and they're made by editing the performance of a Tom Cruise impersonator. But I wonder whether people would really want to see the Tom Cruise impersonator acting in the next Mission Impossible film or not. Where the AI technology perhaps could be different from using actors or impersonators is where there's an attempt to deceive the audience into thinking that the fake video really captured the depicted person. This sort of deception will probably be pretty rare in the sorts of content NBC Universal makes, but it helps it helps us to think about what makes us uncomfortable about synthetic content and the situation where the technology poses the greatest harms. Recently, there were concerns raised about a documentary about the late chef Anthony Bourdain, in which AI was used to create a voiceover in Bourdain's voice. In that case, Bourdain had written the words, but the recording was fake. But perhaps the issue there was that it was not clear to the audience that essentially this was an AI reenactment, and perhaps that could have been fixed had that been made more clear. Susan on the last panel talked about the importance of establishing principles that creators and users of AI adhere to. And I think the principle of transparency, ensuring that those who experience or are affected by AI know that the outputs that they're experiencing were generated by AI, is a really important principle in light of that issue. And the final thing that I'll say is that the New York legislature passed the nation's first ever digital avatar right of publicity statute just last year, and it zeroes in on that deceptiveness issue. And it requires consent to use an avatar of a deceased performer where the use deceptively gives the impression that it was authorized or endorsed by the heirs. That law also has protections against using digital avatars of real people to create fake sexually explicit content as well. So it seems like the New York's approach to this may be charting a decent course on the issue. And with that, I will hand over the time back over to Donald.
Great, thank you very much, Ian. Your comments about the customized messages makes me think about when I was a child. I got a book where Big Bird and Snuffleupagus were talking to me with my actual name typed into the book. I think we've come a long way from that. So with that, we'll turn it over to Brian Mills, who will give us the last of our opening remarks, and then we'll have some inter-panel discussion after Brian's comments. Brian.
I don't know that I'll be able to follow Snuffleupagus, but I'll try, Donald. Brian Mills, I am an attorney at Capital One, the financial institution. I am a technology attorney supporting a bunch of different lines of business within Capital One, some of which is our Center for Machine Learning and other enterprise machine learning use cases. I think as the kind of quote unquote bank attorney here on the panel, I drew a little bit of the short straw, and we'll be pulling back to the abstract for our panel and talking a little bit about tax and tax policy. If you've read my bio, you will see that tax law is notably absent from my expertise, but I will take a stab at it. One of the things that we kicked around a little bit is like, what is tax policy and how does tax policy impact machine learning currently?
All right, I'm going to suggest, Brian, that maybe you exit and shut down your browser and try to come back in, and we'll look for you to pop back up. And please just go ahead and unmute at the point in time when you come back on, and just let us know you're back. In the meantime, I'm going to invite the other panelists to use this next period of time to offer any comments you might have had on things that you've heard from the other panelists so far, any reactions, any ways in which your interaction with AI is differed from the perspectives of some of your co-panelists. And while you're thinking about how you might respond to that, I want to let the entire audience know that you can use the Q&A box at the bottom of your screen to submit some questions. We will get to the audience questions very soon. And I also want to take a moment to let you know that as this conference is virtual, we must verify attendees who are seeking CLE credit for the Virginia State Bar. And so there is a panel password that I put in the box to everyone that can be used for getting your CLE credit. So the CLE password for panel 2 is RBATTY. RBATTY. That's R as in Romeo, B as in Bravo, A as in Alpha, T as in Tango, T as in Tango, and Y as in Yankee. So RBATTY is your panel 2 CLE password. I will paste that again in the box, the chat box, if anyone needs it. And with that, I'll ask the panelists to give some remarks on what they've heard from others. And so maybe Mark, can we start with you? Any thoughts on what you've heard from the other folks?
Yeah, it was quite interesting. Deep fakes, I think, is such an interesting topic these days, and it comes up in so many different contexts. I was really intrigued by some of your comments about the creative elements and how you can use avatars in film and the creation of new works, and it's really is interesting. But in particular, I thought it was really interesting. More of a comment than a question, but this notion of using actual historical figures or living, not actors, but the potential to put them in a film in a fictitious setting. And then the implications that might have, I mean, it could potentially be something defamatory, I mean, or it could be completely, mischaracterized. I'm thinking, the Pelosi making her look drunk sort of thing that they did, for example. So I'm just curious kind of your thinking or NBC Universal's thinking on those sorts of situations where it's not creating a fictitious character, but rather taking a real life person, a known person, and putting them in a particular fictitious setting that they may find offensive or defamatory. And how does that play out?
Yeah, no, that's a great question, and it's a conversation that we had a lot in connection with the New York publicity bill that took many years to finally land where it did. I mean, our view on it is that like Once Upon a Time in Hollywood, right? It was not about Bruce Lee, but there was an actor that was cast to look like nearly identical to Bruce Lee and to do things Bruce Lee never did, and to say things he never said. And our perspective on it would be if Bruce Lee's heirs would not have had a claim on the depiction as an actor depicting him, it's not clear to us why they would have had a claim for that same performance, just because the technology was an AI system instead. Of course, if it is defamatory, if there is some reason why the content violated the person's existing rights, then that's an issue. And the use of AI, and I think there's one of the prior panelists talked about making sure that just because humans aren't doing the thing, that all of a sudden everyone's absolved of liability. That's not the position, right? We need to make sure that that's not the case. But that's how we kind of analyze it, because otherwise, these reputational concerns are could end up really stifling speech and discussion. And on the Nancy Pelosi thing, I think is separate, because I think that falls into the more of the deceptive intent situation than fictional content where you're trying to tell a story and not necessarily deceive anybody.
Can I see much that Brian's back?
Yes, I think we do have Brian back. Brian is going to appear by phone. Brian, let's give it a try.
Can you all hear me?
Yes, we can. This is great.
Thank you. I'm glad that debacle was recorded for all of time. I'm back. Like I said, I was going to touch quickly on tax and tax policy as it relates to machine learning. I'll try to do it more quickly given the time constraints. The concern is that governments will lose out on tax revenue as tax bases and related income taxes decline, and a tax on robots would also serve to curb the pace of innovation and permit retraining of employees to take place. The why behind that is arguably current tax policy favors innovation by taxing capital differently than labor. For example, there are no payroll taxes on capital, and you're able to accelerate deductions for capital expenses. And so, what's the response to that? Well, Bill Gates and others have argued that when a robot or automation displaces human employees, government should tax the robot based on the displaced human's salary. Unfortunately, there is no agreed upon definition of what a robot tax is or what a robot tax would be. The proponents in favor argue that it would level the playing field by removing tax benefits for automation, which would essentially leave decision making to be made based off of efficiency rather than tax policy. Automation drives unemployment. A robot tax could slow job destruction by allowing the retraining of employees. And it could counteract tax avoidance by taxing a robot in the tax jurisdiction in which the robot is located. And could provide the basis for universal basic income. The cons, or the arguments against, are that a tax on robots is untenable. Like, for example, how would one define a robot? Potentially leaving out, either taxes on AI or software automation, or by applying taxes in different industries in different ways. For example, is a robotic, arm in auto manufacturing, a robot is a automated forklift in an Amazon warehouse. Is that a robot? Those sorts of questions. Robots replace routine-oriented jobs, things that require repetitive tasks, which actually increase overall productivity. And the tax could encourage a shift to cheaper labor locations versus automation, ultimately leading to poorer working conditions. And a robot tax would damage innovation, which is bad on the aggregate. There are some alternatives, versus calling it a specific robot tax. For example, you could tax capital versus labor, focusing taxes on high capital companies, which would essentially increase corporate taxes across the board, or other social interventions which would slow innovation and encourage the sharing of wealth. For example, wealth or land taxes, removing the stepped up bases. You could even go with some sort of unemployment type tax scheme where employees are taxed based on jobs lost to automation. Or alternatively, we could do nothing and stick with the current tax policies. The argument there that they're flexible enough to handle automation, and history has shown that innovation causes a surge in demand, causing a boom in employment. Evidence in support of that is that total factor productivity is up and unemployment numbers are down across the board. There are plenty of questions, like, for example, how would you identify jobs that have been eliminated by robots or automation? What about robots that augment human jobs? I think an example that may have been mentioned by Dr. Abbott this morning was robots assisting nurses in Japanese nursing homes. Those robots are actually increasing the productivity of those nurses and actually decreasing the turnover rates within those roles. And then, how do you handle taxing or incentives across country lines? Like, could you create a taxation race to the bottom from an AI perspective? Those are all, obviously questions. I'm not trying to present answers or argue in favor or against a robot tax. I did want to read one quote, and this is a quote here. "We are afflicted with a new disease of which some readers may not have heard the name, but of which they will hear a great deal in years to come, namely technological unemployment." That sounds ominous, but what's interesting about it and why I included it is actually a quote from John Maynard Keynes back in 1930. So this is not a new problem. It is not a problem that we have not addressed. It's just a similar problem by a slightly different name. Donald, I'll kick it back over to you.
Great, thank you, Brian. And we have a comment that came only into the panelists, which I think is very fitting for our current program, and that is, how do we know it's Brian and not a synthetic fake voice that was just presented to us? But Brian, we're very happy that you were able to come back on and rejoin the conversation. I'd like to take a few more moments before we turn to audience questions to offer the opportunity for panelists to discuss amongst themselves. And Mark had a very good question for Ian. I think, Nicole, is there anything that you heard from your other panelists that you'd like to comment on, or questions that you thought of that you might want to ask someone else that has presented?
No, I just want to comment on this. I think everyone's talking about deep fakes now. I think it's the new hot topic. It's just very funny how different industries and companies deal with synthetic data or deep fakes a little differently. I will say for us, we have synthetic data issues, but we don't have much deep fake issues. Ironically, we don't deal with people per se in that respect, but a lot of our issues are more around healthcare data. And obviously there's a lot of privacy implications with that. So you don't want a situation where you're in essence putting my healthcare and anyone else's healthcare information out there. So you actually use synthetic data to kind of, in essence, essence, change the data around while keeping it somewhat in line to someone who's diabetic would have these particular symptoms, just an example per se. So actually we use in a very different context per se. And then also the other area we've kind of used it in is actually with natural language processing issues. So documents. So in essence, instead of creating a document that we have to get copyright proof from someone else, we can create our own synthetic document that has certain language texts in there and so forth that would be in line to a particular language or particular vernacular, particular colloquial terms, but yet it's not something that's generated by someone online. We've actually created that in-house with an AI model. So we have authentic data. We use it in very different ways, obviously, but it's just very interesting how deepfakes is getting this horrible name attached to it, but there's another area of that same kind of data that actually can be used for good. So just a little comment on that as well.
Ian, any thoughts that you'd like to share?
Yeah, I mean, I guess I wanted to just echo something that Mark said, which was the importance of finding a way to protect outputs of AI. You know, it maybe it's copyright, maybe it's something else. And I think there's a question in the chat about this, about, you know, what, does this promote the progress of science and useful arts to protect these outputs? And I think, you know, for us, developing these AI systems, running these AI systems, using them is still going to require investment, still going to require, a reason to do it. And, and right now, I don't think the issue is, at least for TV and film content, is really coming to the fore, because humans need to be so much in the loop. And it's much more like using an assistive tool than actually having a system make its own decisions. But perhaps it's coming in other creative fields, and to the extent it is, and to the extent those things have value and people are interested in consuming those things, that we need to find a way for the creators to be compensated, to be able to prevent exploitation of it that's not permitted. So I just wanted to echo that that's something that we care about a lot. Yeah, and in terms of data, another thing that Mark mentioned, I think it overlaps a little bit with what Nicole, you were saying, was about, what kind of data is okay to use to train an AI system, right? And do you need to obtain IP permission or IP rights from whoever that owner of the data is? Clearly, if it's private data, it's governed by certain, individual rules. If it's copyrighted content, then that's a question. I can see how it's incredibly, if you need thousands and thousands and thousands of hours of footage to train an AI on something, it may be very difficult to enter into the licenses to do that. And particularly when we want to have really good footage that isn't going to create unintentional biases and all the things we've talked about. So that's definitely a problem that needs to be solved. And I think it's something, though, that probably needs to be solved as a collaborative matter between content owners and the developers of these tools, as opposed to what seems to be happening, which is that the developers of these tools are just sort of going out and doing it and saying, well, we're probably protected by fair use or something else, and by sort of daring people to challenge them on it. So those are just a couple thoughts I had on those issues.
So Ian brought up one of the audience member questions. I want to turn to that in just a moment, but Brian, I want to give you a chance to offer any comments that you have on your prior panelists' comments.
Yeah, thanks. I actually think I have a question for Nicole, and Ian touched on it, maybe him as well. He touched on it there at the end, and that is around fair use and how that potentially applies with regard to data. Are there differences from data that is scraped off of publicly facing websites for use, if you're talking about like deep fakes and images, versus other data sets and like data provenance and all those sorts of questions? And so how does that play into fair use and the argument that you're using that data to train an AI algorithm? Is there is copying allowed in that context?
It's very fact specific. It's like anything else. Everything depends. In all honesty, I know there was a case not too long ago, Google v. Authors Guild, and they actually did talk about that with fair use. And they talked about the use of, in this case, was using literary works to train AI model. Part of the issue I think you have here is you have a situation where different data is collected from different places. So there is no one source in which people are getting all of their data from, for the most part. So in essence, to use fair use, you'd have to use it against every different pieces of data you're getting different sources from. So yeah, you could probably do the fair use analysis, but it's so fact specific, and unfortunately, there's no case directly on point with scraping data as a whole from the web. So any analysis you do is going to be, at best case, I jokingly say, a guesstimation at best case, because there's nothing on point at this point. And it does turn a lot on how it's used in commercial usage. There's a lot of different nuances in the fair use analysis. And I will also say, and also is a slightly different point, but looking at the recent Supreme Court case with Google v. Oracle, even fair use, I mean, how the court analogized that case and analogized fair use, I would not have come up with that kind of analysis. So even judges differ as well as far as how they'll how they in essence give certain weight to certain factors versus others in fair use. So fair use is not really a good thing to hang your hat on at this point, I think. I don't know if Ian feels differently. Ian.
No, I agree with what you said, Nicole. I mean, it's incredibly fact specific. I mean, you mentioned the Authors Guild case, which went in one direction, and then the TVI's case, which followed it, went in a different direction. And that the TVI's case, for those who don't know, is one where there was a service that was just recording everything that appeared on all channels, all TV channels. Remember when people used to watch TV channels? Does anyone do that? Anyway, they did this, and that was considered to not be a fair use. So it's yeah, and you can talk about the training part versus like the kinds of results that were being spit out by the system, and that may be a distinction that's important. The Google v. Oracle, which talks about the purpose and character and what innovative means. I have a feeling someone's going to try to use that for an AI system to say that, well, it's for an innovative purpose. So that's following Google v. Oracle as fair use. It's going to be very fact specific and not clear how that's going to come out.
Mm-hmm.
Mark, do you have any comments on this question or anything else to add?
No, I mean, I think this whole question about fair use, I kind of made some allusion to that I don't think that just because it's an AI process, there should be any specific carve out or exception to copyright to use it. There's also, I think Ian made a reference to sort of autonomous generated content. When we're trying to think through this, I kind of alluded to this as well in my remarks. I sometimes think of I'm old enough to remember Rosie the robot from the Jetsons. I don't know if you remember George Jetson and the robot. And so, you think about currently anything AI is a tool used by humans in a creative process, right? So there's still it's like a trumpet or it's like a piano or a guitar or something else that the artist is using to create something new. When we start thinking about autonomous music, I go back to Rosie the robot. That she's programmed to be the maid, clean the house, not to create music. But if she were to tune into the ambient music in the Jetsons' home and spontaneously start creating music, I mean, that would be ultimately an autonomously AI generated content. So I just want to kind of highlight that because I think it does raise this question of how much human content has to be included, what constitutes human contribution to make something copyrightable and protectable. Most of the uses of AI that we can conceive of today would have some element of human contribution to it.
So let me spin off of that human contribution for a moment and ask this. Normally, the law has been able to adapt to innovation. We find new ways, especially in property rights, to identify new property rights, to identify new IP rights, to make them judicially administrable. And as Ian pointed out, I believe it was, there needs to be ways in which you can prevent exploitation and encourage creativity. And I think you need enforceable rights to do both of those, certainly to prevent exploitation, because we need some way in which they can be judged. But when Mark, you bring up the idea of the level of human contribution and trying to figure out how much is enough and all this, and then the possibility of autonomous, is this something the law can actually adapt to, or is this something really sui generis that's just different and maybe the law can't adapt this time, especially if we're asking judges to figure out these kinds of delicate questions about how much is enough. What's everyone's view on this? Can the law adapt? I would point out one other sort of concern in this, and that is the ubiquity issue, especially when you get to something like deep fakes, or when you get to the generated fake content. If it becomes so ubiquitous, in which there's also traceability problems as to who's actually responsible for it, could AI get so out of control that really the rights become so diluted, or the violations become so numerous that there's no real ability, they're no longer the kind of enforceable rights we think of. They're kind of the things you just have to live with. So those are two ways in which I'm wondering if the law can adapt. First off is, can we create judicially administrable rules that, if we did give copyright protection, would prevent that kind of exploitation in the way that we can right now with other IP? And second is, is there a risk that AI will create ubiquitous infractions to the point where the value of enforcing against the infraction becomes basically zero?
I can. Why don't I start with your second question, because I think it's kind of interesting, because it kind of matches up with conversations that we have about Section 512 of the DMCA, because I think, and that's about notice and takedown and the responsibility of platforms to not have content on them that is infringing copyright. So let's presuppose for a moment that we have solved this issue about protecting the content in the first place, and that is protected by copyright. If you look at what YouTube does, right, they don't have people watching the content to decide whether it's infringing and take it down, right? They have a tool, and it may even be an AI tool, I'm not sure. I mean, it's a fingerprinting tool that actually automatically finds this content and takes it down. And so I wonder if there are technological solutions on the traceability issue, and that, in the same way that platforms have a responsibility to make sure that content that violates people's rights or violates their own terms of use are not appearing on these platforms, that those responsibilities should translate through to the sorts of things that you're talking about. And maybe that would go a long way towards solving, or at least starting to address the issue. In terms of, from at least my company's perspective, and I have to admit, we haven't thought really deeply about fine art and music and maybe some other creative work. Like, for us, we feel like, the current legal frameworks are fit for purpose in terms of protecting the kinds of outputs that we create that are protected by, that we do. Because for us, as I mentioned, for the foreseeable future, for quite a while, the humans are going to be very much in the loop here. And so the way that copyright is set up right now is perfectly fine, to do that.
I guess I'll take a slightly opposing view on that last question as well, which kind of also bleeds into the first question. Although I do think we have good IP structure in place as of right now, I think it works for technology as it is right now. I think when you look at where AI is going, I mean, obviously, if you've read Ryan Abbott's book and about AI inventorship, we have, and if you even watched iRobot, which came out 20 years ago, you'll see how technology it can be leaps and bounds of where we are now. And nothing that we can conceive as of right now may be the reality 20 years from now. I mean, I don't think any of our forefathers anticipated a cell phone. So this is just to tell you how technology changes so much. And so I think as of right now, the current structure we have works. But I think as we kind of, especially with data and AI, and as AI models become more sophisticated, and some cases become a little separate from a human intervention. Because let's be honest, I mean, I see on my end when we're drafting even a patent application with AI models, there is this black box option in there that sometimes we don't know 100% what's going on to make this output come out. In some cases, not all cases, in some cases. And when you're trying to describe that in an application for a patent, just an example, you're running into 112 rejections because you can't really fully explain it in a way that can be understood because you may not understand it yourself. So I say all this to say that I think we need to be a little more creative with our structure, and I don't know if there's anything out there that's a correct fit, or any country or place doing it exactly how it should be in the future. Because I mean, if anyone listens to the WIPO conversation, I think everyone has their own secret sauce they're using, but nothing really fits the round peg the right way. So I think we're still going to have to be jostling with it and being creative with the law at this point, until a case kind of goes to the Supreme Court that kind of sets the tone per se, which, as we all know, takes years to happen. I think we're going to still kind of be trying to think outside the box. There's no right fit for some of the technology that we have out there, I think, my opinion.
I can offer a couple. Sorry. I can offer just a couple of thoughts as well. Just kind of bouncing around and reflecting on some things that some other folks have said. I think I would also agree with Nicole. I think the existing legal structure currently works for what we have. The law is about evolving and changing over time to address different scenarios as we need it. I don't think it needs to have a sui generis approach entirely. I think the foundation needs to be, the same principles that apply in the physical world should apply in the virtual world. Just because we can do it online doesn't mean that all of a sudden we can do things that technically we might be able to do things, but it doesn't mean they have a totally different structure just because we do something online. Ian had mentioned earlier also this distinction between use as an input versus how we treat the output, and that's I completely agree with that. As I was referring to how our content is used to train an AI on the input side. I think the licensing environment gives us an opportunity as private parties to negotiate and contract something and talk about those different issues and come up with a creative way to address them. The issues around output, I think, are much more challenging in terms of ownership, liability, who has accountability, responsibility, et cetera. But, Don, you raised the question about enforceability, and I think enforceability has to be part of this. Just the sheer volume that AI can generate of things, presents a practical problem. But I don't think that just because AI can generate new content at scale should exempt AI operators from compliance with existing law or enable them to then use protected content without permission. I mean, that is, how creatives make their living, and our business models built on, like, we want to license our content. That's what we do. Let's agree terms to license it.
Brian, any thoughts on these questions?
Yeah, I think I would take a bit of a middle ground between Nicole and Ian, more like Mark. And I agree that the law changes over time, and while it may not be specifically fit for purpose to address these nascent issues with AI and machine learning and its use in creating copyrightable content, or infringing on other companies' content, or other people's rights. I think the law itself is flexible enough that over time it will continue to evolve, and we will continue to make changes and tweaks. And Nicole's point, there may be a Supreme Court case, or there may be some other a place that eventually will get more answers and more concrete like marching orders. I think the good thing for all of us on the panel is that it's sufficiently gray that we're going to have a lot of work for the next, for the foreseeable future, as we try to wrestle through these issues as the law catches up.
Mm-hmm.
Great, thank you. I want to turn to some of the audience questions. I think we've largely answered the first question, but I'm going to present it to you. And if anyone has any additional thoughts on that question, please feel free to chime in. I'm going to give sort of the first two questions together. One is about what would the logic and social benefit to provide copyright protection to AI-generated works be? And I would add to that, what's also the economic benefit? Many of your comments have gone to this, so if you think it's been sufficient, we can move forward. The second part of that question is, would this contribute to the promotion of progress of science and useful arts? The second question is on voice actors, referencing Wes Anderson and his voicing for Cars 4, and the frustration about voice actors being faked, as well as a question about how do we solve the trust issue? That is, how do we communicate the existence of perhaps AI-generated content to the consumers of that content in a way that would create greater trust with them, and verifiable trust, I would add. That is, there might be ways in which we can, unless you are stamped as verified that this is a certain kind of content, then people may not trust it. So any thoughts on those first two questions? And I'd ask each of you to keep your remarks so that we can get to the last two questions. If you can keep your remarks to about a minute, if you have any thoughts on these.
I can take a stab on the question about the voice actor perhaps using an AI to not use a voice actor. Perhaps I think the thing that we need to keep in mind, right, is that there's a ton of law already existing about sound-alikes, right? And like when you can use a sound-alike, like an individual who sings, or talks purposely to sound like another character, and then on top of that, another person. On top of that, you have the distinction between an individual and the character that that they are voicing. And particularly when you're talking about animated content, it may be the case that the actor is, that the IP in the sound of the character's voice is actually not the IP in the person. It's not the person's right of publicity anymore. It's actually the IP right in the character. And so it's a very complicated question. And I would say, since this panel is about economics too, that for a lot of this, there are contracts in place that deal with all of this, right? So, if there's a deal with a voice actor to voice a character, oftentimes, there's a well-established process, particularly in animation, as to, who has first refusal rights when, if you want to voice that character again, and if not, how that works. And so it may be the case that these contracts can be adapted to deal with that.
I think I kind of responded to the first question about the economic commercial interests of copyright, and that's kind of what we're struggling with. But on your second question about public trust, and this is a question that's been bounced around a lot, which I didn't address, but should AI-generated content be labeled? If I think about music, I'm not sure what it means to label music. I'm going to pull up on Spotify or something, and maybe there's something that indicates that a song has been generated by AI. I think it makes a difference, though, if it's a new creation that is entirely new, as opposed to an AI-generated content in the voice of a well-known artist, and you expect this to be the new Ed Sheeran song, and turns out it's not Ed Sheeran at all. It's a computer that's imitating Ed Sheeran. I think the consumer certain fan base would very much, want to know that, right? So I would draw that distinction of whether it's presenting something new and creative and original in its own right, or whether it's imitating something that's well-known and potentially could be deceptive.
Great. Anyone else on those first two questions? If not, I'll turn to another one. COVID. Has COVID affected how companies are considering AI, how they think about AI-based applications and its impact on future jobs, or on how AI affects privacy? Is there anything specific in the current COVID atmosphere that makes for any different conclusions that you might have on AI?
I think COVID has sped up the use of AI-based applications. I think now that I know in the world pre-COVID, AI, yes, was common, but I think so much things have happened during this year and a half, almost 2 years under this pandemic, that AI-generated or AI-based applications have sped up. So there's just a lot more out there than when we first started, when the pandemic first started. And I think that's absolutely necessary because we're all working from home, we're remote. So there's a need to have other ways of communicating, other ways of getting things done. And AI seems to fill that void. So I think that's been huge. As far as privacy is concerned, I think privacy has actually become a bigger issue. I think people are now more, even just think of backgrounds. I mean, we all have very generic backgrounds. Some people just, you don't want everyone to see what you have in your background in some cases. So that becomes a privacy issue. And then I think privacy is not going anywhere. I think the laws of privacy, especially with GDPR, are very strict, and the fines are very hefty. So I think if anything, I think companies are a lot more, they're getting more savvy about privacy and making decisions on AI based upon privacy, because they don't want to have any privacy concerns when they're dealing with AI models and AI-based applications. I think that's actually a big driver now.
Any other thoughts on that?
I don't think COVID hasn't changed our thinking on AI. I mean, I agree with Nicole. It's accelerated our use of switch technology and adoption of new technologies. But on some of the fundamental questions about, the existential questions, it hasn't changed, I think.
So we have about 1 minute. I want to save the last 2 minutes to give each of you a chance to wrap up, but we have about 1 minute for the last question, which is the rules for joint authorship, like joint inventorship, are really unclear. What do you think should be identified as the legal standard of required creativity of a human input to qualify a work as human created work or a joint human AI work if the statute is modified?
That's one of those open questions I talked about. Is like, what is that contribution and how do you measure it? And if you establish a threshold, how do you measure that threshold and how do you enforce that? That's a very, I don't have a helpful answer other than to identify that that's a very real question, at least for us.
Mm-hmm. I agree.
Great. Well, we have just 2 minutes left. I'd like to ask each of you to just take 30 seconds and tell us anything that you'd like us to know in your final thoughts, including perhaps what you are looking to read or what you are investigating as a next step in your own plan to understand this question of the economics of AI better. And why don't we go in reverse order and start with Brian?
Thanks. Yeah, I think for us, in my industry, our use of AI is slightly different or backwards than my other panelists here, where we're not really creating AI content or having our content rather infringed by artificial intelligence. And that isn't a concern of ours. Ours is more around the use of AI in credit modeling and credit decisions and explainability and those sorts of things, right, in terms of fair lending impacts. And so the things that we're looking forward to is learning more and unpacking more around what like model risk management frameworks look like and how we apply our general model risk process to AI and how that changes over time. Going a little bit to the question that we answered earlier about like, is the law fit for purpose in this space? And I think it's sufficiently, gray that we'll have some work to do.
Ian, 30 seconds.
Sure. I mean, for us, I mean, the point I'd like to send folks home with is really that, there's a lot of discussion about sort of scary things that AI will, our future is scary because of AI. And I think what we're discovering is that may be true. We may, who knows, but at least right now, AI is an incredibly useful and beneficial tool for creating all kinds of new products, for making products cheaper to making. I mean, there's a ton of use cases I didn't mention that are just, making it better, making the video look better, all these sorts of things. And they are enabling folks to be trained on new kinds of technologies and do new things, create new kinds of visual effects, all of that stuff. And so I guess what I would want to just, what we're looking at is AI is really as an opportunity for future, products and growth and ways to enable us to make more and better content.
Nicole.
So I want everyone to leave this thinking of AI as a puzzle. And with AI, there's a lot of pieces that make AI work. So it's not just, it's the model as the input, but you have the data, you have the algorithm, you have the human input. And think about all those different pieces and how they all interconnect. And with that being said, I focus a lot on the data aspect because that seems to be the big driver here. But also remember, there are other pieces to this puzzle. Also, keep your eyes and ears open to what's happening on the other side of the pond. There's a lot of legislation going on in Europe, in the UK, which is now at post-break, so they're trying to kind of make a name for themselves. In Asia, the Asian market, like Singapore as well, really be mindful what's happening in the other countries, because a lot of times what they're doing there trickles to the US. It may take 5 years, it may take 10 years, it may take 20 years, but it's going to affect us in some way, shape, and form. And there'll be something similar happening on this side. So just keep your eyes and ears open on legislation in particular, because a lot is happening in other jurisdictions.
And Mark, close us out.
Sure. So, the music industry certainly embraces technology, and we see this really as the future going forward. So I don't want my comments to come across as being anti-AI and anti-technology, because we certainly aren't. We're an industry that was one of the canaries in the coal mine, so to speak, with the internet revolution, and we saw, a huge impact from disruption from early 2000 onward. That's really kind of caused us to kind of rethink how we do our business. And part of that is every day we have conversations about our artists, our music, and how we support our artists. It's all about the music and all about our art. So that's very much core to our thinking as we move forward in ensuring, how do we really celebrate human creativity, the creativity of our artists, and find a way that our artists, and we can monetize that and make a living from their work. And that's what this is all about. It's very tricky to get right, but we want to be thoughtful and careful as we move forward.
Well, thank you to all of our panelists for being part of this important discussion. This has been the panel 2 for the C-IP2's fall conference on artificial intelligence and intellectual property. It's this panel was on the economics of artificial intelligence and intellectual property. The program continues with more programming tomorrow morning, and we hope you all will tune in for that. So with that, once again, thank you to all the panelists, and thank you to all the attendees for watching. I believe, Sean,
yes, Donald, thanks so much. Thanks to the panelists. Excellent session to end us off for the day. And tomorrow we're back at 9:15 in the morning, and we'll have looking at AI in life sciences. We'll look at protecting the AI output, as we've talked a little bit about today, but we'll go into more detail tomorrow. And then we'll talk about trademark in AI. And then finally wrap up with tech policy and artificial intelligence before then our final fireside chat, which happens at the end of tomorrow at 4:45, when we have Jaron Lanier and Grimes, who will be in a moderated session with me, talking about what all this means, what the future will bring, and how folks who are on the creative and technology side are actually thinking about AI and where it's going to go. So thanks again to everyone, and we will see you tomorrow morning at 9:15.